Hello, I am Ray Dickey. Thank you so much for being here. I am with South Carolina, Hudson Valley, and Association Help Now. South Carolina CAI, Hudson Valley CAI, and Association Help Now. I appreciate everybody that is here, and there's a bunch of people from a bunch of other states, which is much appreciated. Today's topic is going to be legal expectations of reasonable when faced with unethical behavior. I hate the word reasonable. We use it all the time. I think it just gets board members and managers in trouble, but the attorneys will talk about why it's there. And maybe there's a solution to it. Maybe there's not. I want to thank everybody that went to the Hudson Valley Expo this week. I thought it was great. Greg?
Yes, excellent. Some really great educational seminars. Tom did an awesome job. Thank you, Tom.
Oh, Tom, you're there. Actually, Tom Ingblom did an excellent job. I received so many compliments, so many, that he was not only informational, but humorous also. So good job, Tom. And I really appreciate you flying out there. It was much appreciated. Thank you so much. Next week, everyone who likes Adam, you could follow him around all next week. He's going to be in Myrtle Beach on Monday. And Tuesday, he's going to be in North Charleston. Wednesday, he's going to be in Columbia, and Thursday, he's going to be in Greenville. It's a lot of Adam. So for your Adam, what's your topic going to be? Because it's really about the topic.
We're covering the legislative update.
And it's one of our most popular topics. Cynthia, do you find in your neck of the woods, you find that in North Carolina, that's a hot topic?
Absolutely, yes.
Okay. And Adam will have some other people with him, and it should be a good time. So I hope that you get out there and tell Adam you saw him on the live stream. He likes that. Maybe you'll get an autograph. I don't know. Before I go any further, let me launch a poll. If you are here for CEUs, click which one you need. CM, ICB, Florida, Illinois. I don't know. Maybe there's another one I'm not even aware of. Everyone has a question feature. That's how you communicate with us today. Please send comments and send questions. I'm looking right now, and I'm disappointed I don't see any already. I love them. That's how we kind of move the program along, especially with today's topic. I think this one could go a lot of different directions, and I could really use the audience help in regard to making it happen and keeping it interesting. So I'm going to go ahead and end the poll. If I ended up closing the poll before you had time to fill it out, Corey, what can they do? You've been here a lot.
They can do the question feature.
Thank you, Corey. I go to Dave. I go to John and Greg. They've been here for years, and they still don't know. I almost feel like they don't even listen to me. So I feel like they tune me out. They're laughing because they probably do. Use questions, make comments. With that being said, let's introduce our panel with who I see first, and that is Corey.
Good morning, everyone. Thank you, Ray, for having me again. My name is Corey Kravitz. I'm the managing principal for Kovich, Schifrin, Nesbitt's Florida office. We're based in Boca Raton, Florida, and we do everything community associations.
John.
John Legumina from the Legumina Law Firm in Purchase, New York. We represent co-ops, condominiums, and homeowner associations from New York City throughout the Hudson Valley areas.
Greg.
Good morning, everyone. Greg Girelli with Girelli Insurance Agency. We're located in Cold Spring, New York, and we have community association master policy insurance programs throughout the Hudson Valley and surrounding tri-state area.
Adam, please.
Good morning, everyone. Adam Clarkson from Clarkson, McAlonis, and O'Connor. We provide community association, general counsel, collections, and construction defect services all over South Carolina from our Charleston, South Carolina office. I'm a fellow of the College Community Association Lawyers, and I'm your vice chair of the Legislative Action Committee for South Carolina.
Mike.
Good morning, everybody. Mike Lezzi with Acrisure, the Community Association Division. We operate in the tri-state area as well as the Carolinas and Mid-Atlantic states, specializing in community association insurance. I myself am located in New Jersey out of our Fairfield office, and am a CIRMS, a community insurance risk management specialist.
Mike, are you ever going to bring your toddler on? We would love to see him. Is that ever going to be possible? You want to think about that?
So I am home today, and I was very strategic, and he's out on a play date right now because I did not want those disruptions. I know how that can affect the program, but maybe I can bring him on one day for sure.
I think we'd rather see him.
Yeah, we would love to see
He's
the color.
much nicer and better looking for sure.
Yeah, we would love to see him. Dave.
Hi, good morning, everybody. My name is Dave Byrne. I'm the chairperson of my law firm's community association practice, Ansel, Grimm and Aaron. I represent HOAs, condominiums, and cooperatives in New Jersey, New York, and Pennsylvania.
Cynthia.
Hey, everybody. My name's Cynthia Jones. I'm a partner with Sellers, Ayers, Dorch, and Lyons. We are based in Charlotte, North Carolina. We serve planned communities across North and South Carolina. I'm also a member of the College of Community Association Lawyers, and I currently sit on the National Board of Trustees for CAI.
Cynthia does a lot along with Adam. You guys do a lot of CAI stuff. Kevin, I don't know if you do a tremendous amount of CI stuff. Do you? While you're introducing yourself?
What's CAI? I've never heard of it before.
Yeah.
So I am Kevin Herzl. I'm the managing member of Herzl Law. So we represent community associations all through the great states of Michigan and Illinois. I am a former member of the CI Board of Trustees. I currently am a CCAL fellow. I sit on the CCAL Board of Governors, and then I have various, membership committee roles in both Illinois and Michigan. And in fact, this afternoon, I'm headed to a CI Expo here in Michigan, and I'm going to do a Q&A for that.
I knew it. I should have just guessed. And John's also been on the board. Corey, really quick, have you ever been on the CI board or anything?
No, I haven't been on the board. I go to the events, but candidly just been super busy and haven't had a chance yet.
Well, there's only like 50 chapters down there in Florida anyway. So I meant every other mile, it's a new chapter. So actually, I think there's 7. Tell me if I'm wrong, Corey. There's 7 in Florida?
Sounds right. It's a big state.
Okay. All right. Tom, Dr.
You should ask Cynthia. She would know since she's on the Board of Trustees. She has to have this memorized, right?
Okay,
Yeah,
Cynthia,
absolutely. I'm sure there's 7.
There's 7, right? Yeah, I thought so.
Give or take a
Thanks a
few.
lot, Kevin.
Give or take a few chapters.
Dr. Ingblom.
Hi, I'm Tom Ingblom. I work for First Citizens Bank. I cover many states throughout the Midwest and Florida. And we're a national bank in 42 different states, do lockbox and association loans.
Tom made fun of me because after the expo, I was so tired and I just kept saying how tired I was. And Tom was just like, oh, you're such a baby. Like, you could never keep up with me. And I probably couldn't. All right, let's do this since it's mostly legal, if it's okay. Let's have Greg and Mike and Tom all jump off, and then we'll have you guys come back. Tom, you should be thinking of something super interesting and tell us in like a minute or 2 minutes. Don't let us down, okay? Also, if anybody wants to jump back on because they absolutely have something to say, by all means do. I don't want you to think that you can't jump back on. Legal expectations of the word of reasonable when faced with unethical behavior. I would like to start off with 4 poll questions, if that's okay. Do I have your permission, John?
Yes.
Okay, thank you. I would not dare to go any further without John's permission. And I'm actually going to start off with one that I thought was a hard one. Okay, let me find it. Just give me a second. This one is, I'm going to say it first. Can you reject a vendor bid solely because the vendor previously sued another HOA? I want to know if that's reasonable. Can you reject a vendor bid solely because the vendor previously sued another HOA? Cynthia, I know I made it up. I thought it was awesome. I was like, Ray, that's a really great one. Do you think I was right or do you think I was wrong?
I mean, you want my smart aleck answer is, you can reject a bid for any reason. Will it get you into trouble? It could. It's a good question. I'm curious. I don't know. It's split pretty closely.
All right. So let me read it out. So 44% said yes and 50% said no. So let me start off with Cynthia since I kind of jumped. Oh, I'm getting compliments about Cynthia already. Even with hearts. Cynthia is my favorite. There's always attorneys I get a lot of compliments about. Okay. Anyway, Cynthia, let's get back to work here. So I want to make sure we concentrate 100%. The question was, can you reject a vendor bid solely because they had sued another HOA. So please just repeat your answer again.
Yeah, so my answer is yes, you can, but you probably shouldn't because you have no idea. Maybe they had a legitimate claim against the other association. I think it's, we don't know a whole lot about it. So if you do your research and find out about it, maybe that's a valid reason to reject them, but be careful.
Okay, Corey.
Part of our due diligence when we review contracts for our clients is to check the court dockets to see how litigious a certain vendor is. And we share that information and print out, the copies of the complaints and judgments and whatnot, especially if it's a big contract. So I think it's part of the due diligence process, and absolutely, it should be one of the calculations in making a decision on a vendor.
John, I never even thought about this until I kind of stumbled upon the question. I didn't think of it out of the blue air, to be honest with you, but go ahead.
Yeah, I mean, I agree with what we just heard. The board certainly has the right to reject it based on that. You do want to avoid litigation. But Cynthia's also correct. You might want to look further into it. There might be a unique reason why there was a lawsuit, and it might not be nefarious. But in New York, we have the business judgment rule, which most states have, that would definitely protect the board if they wanted to use the litigation as a reason not to hire the vendor.
All right, Adam, I want to bump it up a little bit, but by all means, backtrack on your answer if you would like, based on previous commentary. How about if they've sued 2 HOAs? I don't want to investigate it. I don't care.
Well, I mean, as I said, we do the same thing Corey does. That's the exact same way we do our due diligence with the contracts. So I agree with that. But I also agree with Cynthia. I mean, the thing is, I tell, especially when we've got other attorneys go in the office and folks come in for interviews, I'm like, look, you guys are as likely to lose this interview because they don't like the color tie you wear. You're more likely to lose because of that than you are because you know what the hell you're talking about. So, I mean, it doesn't matter how many times they can choose for whatever whimsical reason they want. So it doesn't really matter because they can choose who they prefer, but presumably they're going to have more than one choice. So provided they got more than one choice, why are they going to pick the one that sued 2 HOAs or 1 or 5? Why not pick the ones that haven't sued any HOAs? So,
yep.
But I mean, again, like I said, we pull the cases. That's part of the diligence, particularly when you're talking about a multi-million-dollar project. You always pull the cases and get in detail on those things.
Dave, I was going in Adam's direction because Adam and I think a lot alike. We both have brilliant legal minds. And I was thinking too, like if I saw a vendor that had sued more than one HOA, I don't even think I would investigate it. Am I wrong?
I mean, my conversation with the board with this topic would have been over already. I mean, the board can refuse to hire anybody it wants, other than the employment context, obviously. All things being equal, a board can choose between any number of vendors for any other reason. I don't even know why you'd waste any time on debating it.
Okay. Kevin, so is it reasonable? What do you think?
Absolutely. People do business with people they like and trust. That's the bottom line, and if this basically erodes trust, it's not a good way to start a relationship. Agree with the business judgment rule concept, and they can set whatever criteria they want. The board, I know this is one of the biggest myths in the HOA industry, but they are not bound to accept the lowest price, even though a lot of board members operate this way. But certainly if they're not comfortable with somebody who's been involved in a lot of litigation, don't hire them.
Okay, so I'm not even going to do this one as a poll based on what you said, Kevin, and I'll work my way back around. I had another one that said, I want to buy insurance from Meg. I don't know if you guys catch on what it rhymes with. I want to buy insurance from Meg. It sounds like Greg, Cynthia. Did you know that? That's what I was going for. I know. All right. I want to buy insurance from Meg because they're more pleasant to deal with than even if the quote is higher. I want to use that as a reason to pick this vendor because they're just pleasant to deal with. And I was actually thinking of Greg because he is a very pleasant individual, and I can see people wanting to do that. Kevin, without ruining Greg's sales approach, I just realized, can people do that? Is it reasonable to pick a vendor just because you like them better?
I don't think that should be the only qualification. I mean, you should do research on whether they can deliver the product, but kind of what Dave said before, all things being equal, and you want to pick one vendor over the other, that's fine.
Adam, having a good relationship with a business rep can be very important. So is this just going to kind of fall in line with the other question here? You can just do whatever you want to do. But if I wanted to tell people, hey, this is why I picked this company, is that okay?
Well, I mean, you're talking to a bunch of attorneys here, and part of the professional background for professional responsibility is that attorney-client relationship. And like Kevin said, if you don't have trust, you don't have expectations, and you don't have it built in where they're going to want to work with you and they feel comfortable working with you, then they've got the wrong guy. So they should always be comfortable with who they're working with, be it an attorney or any other professional as well. So certainly they can pay more to deal with somebody that's a more consummate professional. Then they don't have to take, again, like Kevin said, the lowest bidder.
I thought this one was going to be a tricky one. Cynthia, did I go to you already on this? I apologize. I forgot to write down where I was at.
Not on this one,
Okay,
but
please.
I line up with, I mean, I think they're absolutely right. That relationship is so important. It shouldn't be the only thing they look at, like Kevin said, but definitely if the relationship is not good and it's not there, it's terrible. So sure, that should factor into it.
Okay. So Dave, Corey, and John, assuming that most things are considered equal, do you have a problem with the commentary that, yeah, sure, you could pick this company over another one if the quote's higher just because you feel more comfortable with the rep? Anybody disagree?
I don't disagree. I don't disagree, but I will add one point. The contractors that aren't hired, I don't think, again, using the lawyer, all things being equal, maybe there's something we're missing, but the contractor that's not picked has no claim at all. I don't believe. Again, we're not talking employees, talking contractors. Owners may have claims based on things, but again, I think John's point earlier, whether regardless of what state you're in, the concepts are the same. Did the board have the right to make the decision, and did the board operate in good faith without self-dealing? And if the answers are yes to everything, then the owner has no claim either.
Okay, I thought that one was going to be tough for you guys, but so far it has not been. I love to throw things at you guys that are like kind of legal gray areas. All right, Corey, John, move on to the next one.
Yeah, I think we're good.
All right, I think this one's going to be hard, audience. I think they're going to have a hard time on this one. Not answer questions at an annual meeting from an owner who has sued the association in the past. Kind of like the same theme, but this is from an owner, not answer any questions. And let's see what it comes in. Don't say anything yet, lawyers. Let's see what because hey, this person's, they've sued in the past and maybe they're going to sue again based on whatever. Doesn't look like people. Can you guys see it bouncing around like I do?
Yeah.
Okay.
Mostly
All right.
knows.
And I'm getting a lot of questions, which I love. Thank you, audience. All right. So I'm going to end the poll. So 74% said no and 24% said yes. And I will start with Dave Byrne on this one. Dave?
This is a interesting one. And I think, at least in my opinion, this depends on the state, especially because of things I've heard Corey say over the past many months and about the unique aspects of Florida law. But like in the states where I practice, owners don't have a right to say anything at all. So therefore, this might be an easy one. But again, it depends on the state, because I think Corey, like I said, has suggested Florida might have some different types of laws. I'll say one other thing, too, that I have had judges, though, take the position in cases where this has arisen that although a board has no obligation to let people talk at a meeting, open meeting, or annual meeting, once the board does allow these types of things, it must act in that regard in an even-handed, fair way. So obviously, letting certain people who looks one way talk and people who look a different way not talk, that's an obvious no-no. But there would have to be some sort of generalized fair way to distinguish between the people that are speaking. At least that's the way judges have looked at it in my way. And I guess one of the things you could say is we're not letting someone talk because they're litigating. There's active litigation. There's
wait a minute. Don't get ahead of me, Dave. I left it this way on purpose. There's not active litigation. They've sued in the past.
Oh.
And based on the premise that you just said, that you've allowed other questions from other people, is it reasonable for the board to not take any questions from this person?
The limited amount of things that I've had go to court, I would say all the judges in those particular cases across all 3 states probably would say that was unreasonable and the person should have been allowed to talk.
Okay, interesting. Corey, I'll jump over to you since Dave mentioned Florida.
No, I appreciate it, Dave. Dave's
I'm listening.
right
I'm listening
about
to you.
It is state specific. For example, in Florida, there's no obligation to answer questions at all. In some circumstances, if it's a written inquiry, that's a different situation. But at an annual meeting, there's, especially if it's not on the agenda, everyone in Florida is able to speak on an agenda item. But it's not necessarily a question. It's to give their point of view, their comments, get off their chest, whatever they want. But, if someone's litigious and they're trying to, do a gotcha moment, then I would advise my clients not to, interact with that person because they're not gaining anything of it. They have everything to lose.
Okay, so now we're floating around between a couple different things here, which is pretty cool. So it would be reasonable, Corey, not to answer any questions from a person who has sued the HOA in the past if you're uncomfortable with the questions. Yes?
Absolutely. Yeah.
I feel like I could have a job just where I talk everything in simple terms for lawyers maybe, but I mess it up so much, Cynthia, that is just not good. All right, Cynthia.
Yeah, I mean, again, depends on the state. Does the board have to actually answer the question? No, if they're uncomfortable or something like that, no, they don't have to answer the question. They can put it off until later, or they can talk to their attorney beforehand. But, if there's an open session of the meeting where they're allowing other members to speak and they want to block somebody from speaking, that I don't like at all. But I don't think they're under any obligation to actually answer a question from anybody if they don't want to.
Adam, the meeting's going on. They're answering questions from everybody. Here comes Bob. He sued 3 times before, and the board says, we don't even want to hear it, Bob. Reasonable or not reasonable?
I agree with what everyone else has already said. I mean, it's going to depend on the state. It also depends, if you're in South Carolina, it's going to depend on your association specific governing documents, because there's no state right, but the right can be given in the governing documents, despite the fact there's not a state law right. Like Corey said, the biggest misnomer with this is people think that they're supposed to respond. And that's when you have these sessions, the biggest misnomer that board members have is they think they're supposed to respond. And, it's an incredible feat. And I think most of the folks here probably know Scott Carpenter out of Arizona, who's pointed out it's an incredible feat if you can get your board to not do that in a meeting. If they're walking in a meeting, the best thing you can do is do not respond. They have a right to speak, do not respond, because the moment you do that, you're going to say and lock the association into problems. That's where everybody gets in trouble. So absolutely reasonable not to respond to Bob that's sued once or 1,000 times. It doesn't matter. Bob's a problem. We're not letting Bob lock us into another litigation. We probably will, because the board will probably respond anyway. But if we can stop them, let's stop. Let's not respond, because we don't have to do that.
Somebody from the audience had a great comment that ties in exactly what you just said, Adam. Why should the board have to make the legal determination whether or not to answer the question? They should not answer a question from anybody that's had previous litigation. Adam, am I wrong? But that sounds kind of like what you were saying. Yes or no? Or
I just literally copied what everybody else already said. We were all saying the same thing on the circuit right now, Ray.
Okay. All right. John.
Yeah, I have a slightly different take. So in New York, it's the same, right? There's no right to ask to have questions answered. I was at a meeting the other night, and an owner was incensed when, like, you mean you don't have to answer questions? And the answer, no, you don't have to. And it's not part of the meeting agenda, right? It's new business, old business, officer reports. This doesn't say Q&A. But the problem is that it's become a custom that you have a question and answer session, and they all expect it. And I think this is what bothered Cynthia, is like, if you actually start asking questions and answering questions, but because someone brought a lawsuit 7 years ago, and he's got unrelated questions going on, then you get into you're not treating the disparate treatment, which can expose you to a lawsuit. Also, if you're afraid of this person is going to use the answers to sue you, he'll just sue you for treating them disparately anyway. So like, don't worry about it.
Adam, I'm hearing different responses. Are you disagreeing with me? I don't think everyone's saying the same thing.
Everybody's saying the same thing in a different way, right?
Do you think it's because you're an attorney? Audience, help me out a little bit. Is it because Adam's an attorney
That's funny.
and
I'd
he's
rather
looking
go
at
with
this
Adam.
and this is a different approach? And I'm looking at more at the basic knowledge level of a manager or thank you, audience. Yeah, people say they're confused. Exactly. So a lot of times you guys have to realize my knowledge level is that of an average manager or board member. So yeah, Adam, you're hearing the same thing, but I'm not. I'm hearing different things. So I don't know. Kevin, can you help me out a little bit here?
I'm going to give you my best lawyer answer here is it depends. So where I would draw the line, if it's something simple, you know the answer to, and they're just asking you, what's the assessment for next year? You've already gone over that. Just go ahead and answer it, be done with it, move on with life. But kind of what everybody else is saying, where I think people get into trouble is that humans are innately wired just to give answers and be helpful. But if you don't know the answer, don't give an answer. At that point, I'm going to go with one of your favorite lines that we talked about, I think on a prior one is, when you said, thank you for your comments, I would say, thank you for your question. We'll look into that and get back to you if you don't know the answer, would be the way to handle it in that situation.
Don't forget, Kevin, I said I would never say thank you to some jerk. I always said, okay, we've heard your comment. You guys are
Hey, you said you wanted a controversy. I gave it to you, Ray.
All right.
For the questions, okay?
Corey, we'll let you wrap this one up. I mean, I'm hearing you don't have to say the thing I don't like about Kevin, what some of you guys are saying is you're leaving it up to the board member to decide if this is a question that could get him in trouble or not. And I feel like sometimes we tell our boards don't start making legal conclusions. Kevin, am I wrong before I jump back to Corey?
I don't think you're wrong on that. I mean,
okay.
most boards don't have the bylaws memorized and can't tell you exactly what all the rules are. So I'd say that fits into don't answer if you don't know.
Corey, blanket question. Can the board just have a policy? Look, if you've sued the association, we're not going to answer questions. Probably not, but go ahead.
I mean, they can if they want to, but there's a personality battle that's going on that's underlining as well. If this person is a troublemaker for the association, maybe the board member doesn't want to be involved, or maybe the opposite. Maybe the board member wants to get under their skin a little bit. So sometimes there's personalities that get involved too, which really shouldn't. But I think Kevin was right in the sense that if it's something that's not a litigious or controversial question that you can answer, when is the gate going to be repaired? When is the clubhouse going to be painted? If you know the answer, there's nothing controversial there. But if it's something that they're trying to get you in a gotcha moment, or something that could potentially be used against the association, then it's best to defer to this, say, we'll get back to you on that, or on the advice of our counsel, we're instructed to not answer that, and the counsel will get back to you.
Greg, just jump back in. You're not in isolation. I don't mean to make you guys think it's like a game show and you're in like some booth where you can't talk and hear. You don't have to send me text messages if you have a comment. Go ahead.
You told me to use the chat feature. I use the chat feature like I'm supposed to.
Did I? I apologize. Oh, go ahead.
I'm kidding. It's like the rest of the audience. But no, in general, if you have somebody that is such a concern, and to avoid having to deal with me or Mike on an insurance claim down the road, the attorneys, I think, should be invited to the meeting and should be at these types of meetings. If you have those types of issues coming around and being of a concern, because that could help you alleviate what could become a problem.
I like it, Greg. Why do boards even answer questions at regular meetings? Why don't they just say every now and then we're only going to answer questions if attorneys are there?
I mean, a lot of these meetings are probably normal and they're normal questions and just fine. But when you have somebody showing up and you may know that there's an issue and they're going to bring up a topic that's dangerous, let's say, to answer, good meeting to have your attorney at.
I'm going to move on, but why do you guys always assume that the board knows which questions are dangerous and which ones aren't? Why are you always assuming that? Because a lot of them don't. So, I meant.
Sure.
Anyway, all right, Dave. Anything to say, or you just have indigestion, or
No,
you're having?
I don't know. I've just
Okay.
board. I've experienced boards not doing very well when they defer things to. You have to talk to my lawyer here, like it's a congressional hearing or something. It's very politically difficult for a board to do that and get reelected. That's just my experience.
Okay. Anybody want to add commentary to that? All right.
Yeah,
Let me.
I mean, real quick, I mean, there is a political aspect to this, and Dave's right. Like, you can't, why you don't have to answer questions. Oftentimes, if you don't, it's just going to get worse.
Right.
But John, there's no political aspects to anything we do. Everyone has
Yeah.
to follow best practices and do what's in the best interest of the association at all times. What are you
Fair
talking
enough.
about?
Fair
No
enough.
one's political. All right. Let me go to some of the questions from the audience. I will start with Adam and go the other way around. This isn't a question. An owner in a large community I manage had to agree not to speak about the subject matter of a lawsuit. That is very common. I don't think anyone has any commentary on that. Anybody? Okay. What is the best way to take questions from owners to the board in writing? I'd rather save that one if you don't mind, because it'll get us off in another direction. I'll make a note of that and get back to you on that. A lot of people were kind of confused. They thought they were hearing different answers. One board, one voice. So they're not, this person isn't really for the answering the questions because they feel like the board should speak in one voice to answer the questions. What is reasonable when there is an ARC violation? Wrong roof, shingle color. They must be removed. Wrong fence, but owner pays fine and refuses to correct. So I know this was going to be a big part of this, Adam. Why don't you jump into it?
So what is reasonable about what?
ARC. People are really kind of confused because it kind of becomes a judgment call sometimes, right? Architectural review. I don't want to do a whole topic on it, but you know what we're talking about here.
Oh, generally it's going to depend on what the association actually has in place and has established and what kind of rules you have in place. The problem that I run into the most is associations don't have these things set and they're just making them up as they go. So, like, for example, if the association was constructed 5 years ago and you didn't track what the roof materials were, you decided that this year that this is the roof materials that can use moving forward, which, by the way, isn't necessarily matching the roof materials that were already established, the board can't just change that. So that's not reasonable. And if you're going to be looking at, and so when you're getting into that, you're getting into matching on an architectural level, a reasonable board, and in a lot of cases, needs to be kicking that out to an architect who's going to come in and do the review and make sure that it does match the community standard. Because we're seeing a nationwide trend in the cases that the courts are tired of seeing boards make stuff up and just go with whatever they want, because you shouldn't have 3 or 5 people deciding arbitrarily for 3,000 people what the houses are supposed to look like. There's a standard that was established by the developer. It's already in place. It should be relatively consistent. And there's a real way of continuing that, which is continuing with what was originally installed and using an architect to make sure the design remains in compliance. So, that's your high end answer. On your low end, it's going to be really hard to do that. If you're trying to map shingles in a trailer park, people don't care. Nobody's going to get your architect to come in place. So you're going to be sitting there trying to figure out what else to do. And it might be close enough where it's using hand grenades. So again, it's also going to tear to the nature of the community.
Kevin, I think this is a hard one too, because people get really upset about this one, right? Owners, go ahead.
So a couple things. One, I don't like to talk about violations in a meeting. So if that comes up, I typically say this is not the appropriate forum. 2, I generally try and discourage people from using fines for architectural control issues that relate to permanent structures. They're never an effective use. You typically have to go to court to get somebody to change a building and that kind of thing. They're great for things like bird feeders, garbage cans, a lot of the little things that typically don't need a lawyer. But when you're, getting into things like schools, somebody painted their house color hot pink, that kind of thing, I just don't find it to be very effective, because a lot of these fines are $25, $50. People will say, I'll gladly pay the fine and keep my hot pink house. And so typically, in those situations, instead of wasting time with that, send them a demand letter, give them some time to fix it. If they're not willing to do it, you really need to go to court to get an injunction. Otherwise, you're going to end up with a lot of, issues, and everybody's going to start doing it.
Dave.
Yeah, I like Kevin's point about the fines too, with the structures, but I guess more on topic. I think if you deal with individual things, even in the political context, it's almost always better to defer by using language like, this is a private matter, let's talk about it after the meeting, let's talk about it tomorrow, please contact management, we're not aware of it. Those are things that I've experienced as being more politically palatable to defer those kinds of things. People in the room will be more likely to take your side because they don't want their questions to be held up by someone's personal individual problem.
So, Dave, have you ever thought about running for office? You seem like the consummate politician here.
Oh my gosh! Don't ask Dave his political views.
I tried that, but the Oppo research dump.
Yeah.
I was out of the race in 3 days. So.
Yeah, I could. Yeah. Cynthia, let's take it out of the whole meeting context, right? It's not a public meeting. The ARC committee's sitting around and they're not really sure what's reasonable or not. Somebody brought something to them, and on paper it looks fine, but it's awful. What's reasonable?
Well, I mean, in North Carolina, there's really broad authority for our ARCs to make decisions based on just what they think looks good in the community. So, I think some of it will depend on the authority the ARC has and the governing documents in the state and the case law that's existing in the state. We're very, very broad in North Carolina. So if they think it just is going to clash with the neighborhood, they've got authority to deny it in North Carolina and either fine, and I agree with all the comments about the fines, or go to court to have them stop it. But not all states have that. The underlying issue, I think, that's really important is you don't treat different people differently. So if you're going to deny it for one person, you deny it for everyone else. If you're going to allow it for one person, then you better be allowing it for everyone else. That's what's going to get you into trouble.
And then, Cynthia, I'm going to jump over to John, but I'm going to use your comments, so feel free to interrupt me or go back if I need to. John, but not everything is always the same. This is a hard one to tell what exactly is equal, right? Because it's based on visual, right? It's really hard to determine if you're discriminating against someone and you're not. I can see a lot of boards getting in trouble for not being reasonable when in their minds they totally were. How can they guarantee they won't be?
So Cynthia makes some really good points. And in my experience, this is one area where courts will really give a lot of deference to boards' decisions. They're not going to, it's more than the business judgment rule. They're going to enforce colors, right? It has to be this color. And the exception is, and a good defense to a lawsuit will be, you allowed all these other colors. And so you do have to be uniform. But if, assuming you're uniform, you're going to be able to, at least in New York, enforce, for example, that you need to have a conforming window. And if you're, and that's pretty easy to, you either violate it or you have a standard. As Adam suggests, hire an architect to help you develop the standards. And if you don't follow it, even if to a reasonable person on the street, you can't really, that's not a big deal. I think a court will enforce it. So I think this is an area where you could actually be, quote unquote, unreasonable.
Same thing, John, if I'm misrepresenting something. Corey, I just thought of something that John just said. Like, is it ever make sense for a board just to hire an architect, sometimes like a third party, if they're not sure? It's like borderline, they're not really sure. They know there's a potential for a lawsuit. Is there any way they can hand this off to an architect and let them make the decision whether or not you're following the guidelines?
I would take it a step further and have the architect, before there's a dispute, to help prepare the guidelines that would be acceptable. Afterward, you don't really want, the architect's not a decision maker. The architect's not a judge. He can be an expert witness, say, here's my expert opinion, but the move is to do it beforehand.
Adam, I've never heard anybody say that. Do I get credit for that? Seriously. Hiring an architect seems like a genius idea. Corey, did you know about that already, or did I just create a whole new concept?
My dad is an architect.
Oh, you knew it already. All
So
right.
I knew it already.
All right. And Adam's never going to give me credit for establishing a new legal precedence. I know it. So I'm sure he'll be using it next week. All right.
There's one thing. I did have one comment, though. There's one thing I heard that I don't necessarily agree with in terms of the fines. I think fines are actually important to use as leverage in a negotiation, because if you go to litigation and the goal of litigation is to get an injunction to turn it back to the way it was. You can't really negotiate on attorney's fees and costs. Maybe a little bit. You can't negotiate really on doing the work. It's kind of black or white. But the fines are negotiable because it's gravy. It's not budgeted for. And in any negotiation, you want the other side not to feel like they're getting completely hosed, that they had a little bit of a win also. So you can use the fine as leverage or as a negotiating point to let them feel that, in terms of complying, they've won on this aspect as well.
All right. Let me have the rest of the panel jump back on while they're doing that. I have another question from the audience, and then I want to get to something about the courts. And then Tom, we're going to go to you. So I want to hear some words of wisdom about what we're talking about right now, or you can just agree with me, and that's fine too. Whatever you choose. What would be a good? I'm going to add reasonable, so it's more at the topic. What would be reasonable, and what would be a good response to homeowners who want to call every time they see someone from a neighboring community walking around the COS of their HOA and using pocket parks, small garden areas at the corner of the streets? Lawyers don't usually like really specific questions, and this one's pretty darn close, but we'll try to fly through this one as fast as we can. Corey, is it reasonable?
I don't really understand I don't really understand the question, but if it's a question of trespassing, then that would be potentially a criminal matter to call the police on, or send a cease and desist for civil trespass. I don't know. I'm not too clear on the question.
Let's put it this way, John. Is it reasonable for the managers just to ignore these kind of phone calls from owners every time they call when someone's walking around the neighborhood from another community when there's absolutely no reason for them not to be?
Yeah, I mean, you have a common areas to maintain. If you're dealing with, almost like these non-issues, maybe you tell the person once, hey, if you think it's trespassing, call the police.
All right, I'm going to just let that one go away unless anybody has any other comments. And the person who sent it, if I think I read it pretty close, but if I didn't get the idea that you were trying to get to, please go ahead and send it back. Really quick, Tom, where are we at with words of wisdom? Because I want to dive into the courts. Or have you ever run into this? We can't hear you.
Yes, I have. I had something different for words of wisdom as I'm preparing for a presentation tomorrow about time management. And I just think that everything that's been talked about, it ties into effective time management and how they deal with the board meetings, and dealing with counsel and attorneys.
I didn't like the segue. I thought that was a pretty loose segue, but all right. It's okay, because you did such a great job at Hudson Valley. You were like a star. You really were. So we're gonna give you a break on that one for today. But that was not, even Cynthia's laughing. That was a pretty rough one.
I'm just getting called out all over the place here, man.
I like having you because it's rare. I like having you because it's like, it's just great to have you on every now and then. Do you know what I mean? Okay. All right. Really quick. Let's start off with Kevin, and save some room for the other lawyers if you can, Kevin. Courts. I mean, is this something you could just lose anyway? You do everything right? Because the judge has to decide now if it's reasonable if you end up going to court.
Yeah, I mean, that's one consideration we talked to all of our clients before. I mean, you may be 100% on right on paper, but I'd say the one pain point is typically judges have a lot of discretion on the attorney's fees. And so that's a business consideration in deciding how far you want to press a lawsuit. But there's always appellate courts, and we've taken a lot of cases up over the years if we didn't get the right result. But part of it is having a realistic expectation of how long it's going to take and how much it's going to cost.
Cynthia, courts deciding whether things are reasonable.
Yeah, I mean, that's what they do, right? That it's a hot buzzword, reasonableness here in North Carolina right now. I mean, the judges are talking about it. Like I said, we could be able to justify it every which way, but if the judge doesn't like it, it's a risk for the association. So we do the same thing Kevin does. We're talking to clients about that in advance if they want to go into court. It's a big deal though, and it depends on the judge.
Dave.
I don't know if I remember the question.
All right. It was, what's the point of all this to a certain extent? Because at the end of the day, the judge is just going to decide there's a point, but judges have broad discretion on what's reasonable. So you could do everything right and still go to court and lose. This is an easy one to lose unfairly. Do you agree or disagree?
No, I agree. I agree. I think,
Okay.
courts are very unpredictable. It's very challenging. I also think that it's not only the ultimate outcome that is unpredictable and potentially frustrating, it's the process altogether. It's the multiple hearings a judge requires, it's that please provide more paperwork, and a board's looking at what it might otherwise be an obvious thing, like somebody is raising cattle on the front lawn of their house, and the board may think this is going to be an afternoon, and by 2 o'clock it's going to be over with, and 2 months later you might find yourself still involved.
But if it's emotional support cattle, it's okay, right, Dave?
Yeah, right.
Adam, as an attorney, I'm getting a little off topic, but I am generally interested. It plays a big factor when you're going to go to on some items. Are you way more confident, Adam, and you're more inclined to tell the board, yeah, we're just going to go to court on this one, while other ones, should attorney be communicating that to the board, or should the board be asking that? Not so much what's right or wrong, but what are the chances of, getting a good verdict?
I mean, certainly we can kind of, to the best of our ability, evaluate a level of confidence, but going back to what Kevin said, I mean, really you're talking about how much they're going to spend. So it doesn't matter if, we know we can win. I mean, it's like, yeah, we could win. If the district court doesn't read the documents, we'll win at the appellate court level because the statute says it. So we're definitely going to win. And there's, we've got comments from the acts and everything else. So when if somebody doesn't read it the first time, somebody read it the second time. But if you're getting into reading it the second time, you're now in a six-figure litigation. You don't want to be in a six-figure litigation, especially over a $5,000 issue. So, I mean, that's a board decision. And we always, we like for them to evaluate it, make sure they understand it, and make a decision that how important it is for the association itself. How important is it for the community to move forward?
So, John, I guess it's reasonable for a board to determine what this whole thing's going to end up costing at the end, whether or not they get involved in it.
Oh yeah, that's the critical consideration. I have two quick examples I always give clients about architectural review cases. So the issue was non-conforming windows. In each case, I told the client, like, you're gonna win, but like you may not really win. And I said one example is in New York, I moved for summary judgment right away. We won the case. Spent less than $10,000 on all the litigation. The judge wasn't going to force this because the owner was like an 80-year-old senior citizen that it wasn't going to happen. They weren't going to hold her in contempt. So it was kind of pointless. The other case was the opposite. We won after the other side had like 5 lawyers, spent close to $200,000. We had to go and bring contempt proceedings to get the owner to, and we actually, it actually worked, but it took years and a ridiculous amount of money.
Corey, any commentary about the courts, any advice for boards and managers, what to expect on these kind of cases?
To kind of piggyback on what John was saying, you can win a case, especially on an injunction type case, but if the person can't afford to redo whatever modification that, if they spend $100,000 and they can't afford to spend another $100,000, the court's not going to put them in jail for not being able to afford it. So that's a and they're not going to be able to pay your attorney's fee. It can be problematic. So, usually these types of cases, if you can get them resolved short of litigation, it's usually the best bet.
Okay, and I'm going to give you guys plenty of time for closing thoughts, just in case there's anything I didn't run into. Let's go to the insurance people, then I'm going to go to the attorneys to kind of wrap up here. Greg, leave a little room for Mike if you can, but where are we with insurance? You get sued, are you going to be covered? You're aboard.
This is what your directors and officers liability insurance is for, is protecting those decisions that you are making through these day-to-day operations. The one thing I liked the lawyers talking about was everybody expects an instant answer right now. It's just kind of in our culture. And if you don't know an answer, don't say anything and don't commit to an answer, and don't try to just satisfy the situation, because that answer, if it's recorded in the minutes or it's at one of these meetings, could come back and bite you later. So watch what you're saying and answering and putting down in writing, and seek professional advice.
Mike.
Yeah, I think Greg hit the nail on the head as far as that's what your D&O is for. A lot of times, boards say, well, what is this coverage for? I don't understand. But, it's protecting them, as you said, making the decisions, not making rash decisions, taking their time, following the rules, regulations. I think just, looking at each instance or potential issue as a process, and not to make rash decisions. Sometimes as humans, we could be very reactionary, and that's not always the best thing. So take your time throughout that process, and obviously seek legal counsel if need be, while working through those situations.
All right, Adam, I'm going to go to closing thoughts, but somebody had an interesting question. Isn't the business judgment rule the same as being reasonable?
No.
It's not? Okay, can you tell me why? Because I was kind of inclined to think that, all the lawyers are saying no, so obviously.
Yeah, a prerequisite to the application of the business judgment rule is due diligence, which is a whole separate thing from being reasonable. You have to do the appropriate due diligence. You have to inform yourself, and then you've got to act in a manner that's commensurate with the proper level. Act in accordance with that in a reasonable fashion. You have to seek out professional advice with respect to other issues. And plus, the business judgment rule is a defense, not really a question. So, and we could probably have 10 hours of discussion on business judgment rules. So I'm just trying to answer this really quickly. But the short answer is no. They're completely different. It's a facet, because did you meet the expectations when you did you do reasonable due diligence? Did you meet the reasonable standards involved with that? But yeah, it's just, they're different, very much different.
Adam, before you go to closing thoughts, on Friday, are you willing to spend from 9 a.m. to 7 p.m. with me for a 10-hour live stream? Because I would like to talk about the business judgment rule with you for 10 hours on Friday. Are you available?
I have a special rate for special folks.
Oh, okay. All right. Now you want to get paid?
Absolutely. If you want to pay that rate for 10 hours, I'll do it. Yeah.
All right.
Yeah, absolutely. Anytime. I'll do it on 4th of July.
And I would also add to that, Adam doesn't have to answer your questions if he doesn't want to, Ray.
Okay. All right. Adam, look at our, we got enough time here. We got a little bit, but what did we not bring up? What's your overall thought on this? Reasonable.
There's an infinite amount of things we didn't bring up, Ray. There's textbooks on this. This is a whole, there's semesters that you spend on reasonableness in law school. So yeah, there's a lot we didn't cover, but one of the things I would say, it's a basic thing I tell all my clients and everybody else, is that it is a reasonableness. There's a sliding scale of due diligence, sliding scale of reasonableness when you're looking at these things. So, it's one thing, as I intimated earlier, if you're looking at a shingle at a trailer park and you're trying to determine this, and we're talking about we're talking about $50,000 unit, you're probably not going to do the same level of diligence that you're going to do when you're looking at and you're trying to debate and decide on, with that individual. And I hate to say that things are different, but if you're talking about the difference between that and a $6 million home, or surrounded by other $6 million homes and movie stars and everything else, when you're dealing with that situation versus the other, which we've dealt with both, you're going to do a lot more due diligence on the aspects of the architectural portions on the $6 million home, because that's what's expected of you. And the same thing's expected of you with everything. That's a sliding scale, not just with the homes, but also with just the nature of it, whatever you're dealing with. I mean, if you've got a contract to get balloons at your next event versus a contract to do a $2 million reconstruction on one of the buildings, it might not be, it might be reasonable to not have the attorney review the balloon contract, but you're insane if you don't have the attorney to review the $2 million reconstruction contract. So again, it's just, and there's a sliding scale all between there. So I think that's when you're getting to reasonableness, part of it is just the sliding scale of what needs to be addressed in the situation at hand.
I like it. So 10 o'clock at night, the board's sitting around at some ridiculous thing. They don't have to feel like they have to spend 5 or 6 hours on it when it's going to have such little impact compared to a more important issue. So you could, the board could take a little bit of pressure off themselves when some of these issues have a lot less impact. Is that correct, Adam?
I mean, I think so, but I've also sat in board meetings where they discussed for 5 or 6 hours the flowers they're going to be in the lobby, and I thought, me sitting here, you guys could have just paid for the flowers for the entire year. You wouldn't have to discuss the debate pricing. But okay.
That's why I thought it was so interesting what you said, because boards do all this time. How come you never brought this up over all these years? This is like a great topic. Okay, we'll backtrack. All right, Kevin.
So for me, kind of the takeaway today is that, not always, but in a lot of these situations, you can just eliminate any kind of ambiguity. You get into these subjective determinations, reasonableness, if you have well-drafted documents. And so that's one thing we haven't really touched on. But for architectural controls, rules, things of that nature, typically you only get into a fight over what's reasonable if you don't have clarity in the governing documents. And so that's really kind of a key to even going down this road, would be my advice for everybody.
I like it. Cynthia.
All right. Well, I'm just going to mention something we briefly touched on, but I think you're well advised as a board to be using the professionals, whether it's an architect or a CPA or an attorney. If you have a question about whether or not you have to allow something or it fits within your architectural guidelines, ask in advance. It's way cheaper to get a 30-minute opinion and someone to look at it that you can rely on than to try and fight it in court later. It's going to be much more expensive. So rely on those professionals.
Dave.
I'll say one thing that I use with clients all the time, and they've told me that it's effective when they're thinking about dealing with a particular legal battle. It goes to things about a lot of the guys have said. I tell clients, before you sort of fight with something or over something, define for yourselves what victory is. So I try to draw the distinction. If you're in a custody dispute over a child and you feared abuse, you'll spend all the money you have and more to solve that problem, and you won't ask about whether you get your money back when the case is over. If you're going to fight with a landscaper, or if you fight a guy over his windows, and at the end, if I tell you, okay, the guy's windows are gone, but the 50 grand you spent, you're not getting back, is that a win or is that a loss? If you say it's a loss, it's probably not a litigation you want to start.
John.
Yeah, so I'm gonna just piggyback on what Kevin was saying. So just as a caveat, even if you have really greatly tightly written rules and findings and attorney fee reimbursement clauses, at least in New York, it's still subject to a court's determining if it's reasonable or not. Courts are notorious for cutting attorney's fees, sometimes significantly, and same goes for fines. Courts hate excessive fines.
Yeah.
And they don't really care how well your rules are written.
And Tom, if you're still there, come back, because I wanted to say goodbye to you. Corey.
Litigation is unpredictable. I always tell my clients I wish I had a crystal ball, because we could be 100% right on an issue. A judge may not get it. A judge may not want to spend time on it. I've even had a judge in one of our more liberal jurisdictions say, well, if that's the law, then the law is an expletive. So I always get court reporters now when I'm in that jurisdiction. Litigation is very expensive and it's risky, and it's unpredictable.
Really quick, Greg, what happens if the DO insurance is less than the cost of the litigation and judgment? Who's responsible?
I don't understand the question.
I don't understand that question either. I have to admit I don't. All right.
The DO insurance can't be less than anything. You have insurance and it may cover to defend.
I think he means if you have $1 million policy, let's say for D&O claim, and the lawyer bills go $1.1 million, is that dollar paid by the board or is it paid by the insurance company? I think that's what they mean, right?
That aspect I get, but that can vary because not all D&O policies are the same. Defense costs could be inside your limits, meaning that 500,000 of defense costs is eating away at your $1 million limit. And some policies, defense costs could be outside the limits where your attorney fees don't erode the $1 million limit.
Okay. And a lot of the audience today said that judges hate HOAs. Sorry, but that's what they said. All right. I want to thank everybody for being here. If you want to join me later with a manager segment, it's at 1:40. Just email me or go on the website and you'll find the connection. A lot of people actually do turn in for those. So it's just managers. It's really casual. Thanks, everybody. I truly appreciate you guys being here, audience and panel. I will see you guys in a couple weeks, I think. Bye, everybody.